Good morning, everyone. North Harrison, can you hear me?
Good morning. We can hear you.
Okay. A little bit of housekeeping. First of all, I did send you guys an email or a message asking you to bring your textbook to class if you can, because I'll be making some references to pages in the textbook that you might want to look at, and there will also be times when you want to look at the Constitution, which is around page in the 60s and 70s. I think it starts at 64. Secondly, I am trying to, I don't know if you're finding this helpful or not, but I am trying to respond to issues that you raise in the discussion board, and I will continue to do so. And some of you have made interesting comments or asked interesting questions, and I've tried to respond to them. And so you should take a look at them and think of them as a kind of way that we can chat and add to the material that we've used in the PowerPoint presentation. Number 3, you should be reading chapters 4 and 5 in the Bardis textbook. You should keep in mind I posted some days ago a message regarding a changed due date for the first paper assignment. That due date is in 5 days, this Sunday at noon, I believe. If you have questions about the paper, your paper specifically, you really don't want to wait until Saturday to contact me, because in my professor's world, the worst thing that a student can do is wait till the last day and then say, oh, it's going to be late, or I can't ask, or I need questions asked, or whatever. It's not like you didn't know that what the assignment was early on in the term. So keep that in mind. I think that's all I have today in the class schedule. I wanted to reserve time. I know this is a kind of difficult format for you to ask questions. You probably find it easier to ask questions or make comments to an instructor who's standing right in front of you, and obviously I'm not. But if I wanted to build into the course time where you could talk and where you could ask questions or make comments, kind of like, akin to the discussion board, things that you might not understand. It's not a criminal act to say I don't understand something. It's not a criminal act to say, gee, Professor Ellison, I didn't really understand your explanation. What are you talking about? That's perfectly acceptable. Just say it with a smile on your face. So I wanted to give you time this morning. Essentially what we've covered so far is the kind of foundations of an introductory American government course. A little bit of the history, whether it's in the textbook or in the presentations in class, the history, the Constitution, the institutional framework that's created by the Constitution, what the significance and some of the effects of that institutional framework are. Basically, that's what we've been doing. So what I need to hear from you is, are you comfortable with where we are? Do you have comments? Do you have questions? I realize it's 10 after 7 on a Tuesday morning. Maybe not your ideal time for questions about American government, but this is our time. So if you have comments or questions, jump right in. Does anybody want to take the leap?
You're all really shy.
Okay. Well, if you're all comfortable, I'm very upset if you're all comfortable because I try to be controversial enough so that nobody is comfortable. Or maybe you're so uncomfortable that you don't want to ask questions. Well, okay, what we'll do then is we'll start on civil liberties this morning. And again, if you do have comments or questions, please feel free to raise a hand, interrupt. Otherwise, we'll start talking about civil liberties. Let me make two introductory points about civil liberties that are not on in the presentation, at least not on any of the slides. First of all, I want to suggest to you that for many Americans and many American office holders, civil liberties and civil rights are, well, like motherhood and apple pie. Who can be against these things? And one of the things I'd like to suggest to you is that when we look at what civil liberties mean and when we look at what civil rights mean, these two concepts involve very different attitudes and expectations toward government. So keep that in mind. We tend to act as though these two things are consistent in terms of what we want, and that they're perfectly coherent with one another, and they may not be. The second thing I'd like to suggest that's not in here is that we've just been, the beginning of the traditional and this American Government Intro course is to provide a discussion of foundations and the institutional framework, just a brief overview. At the end, you usually get issues of public policy. And in the first presentation in the course, we talked about how there are problems looking at American government and politics in that way. And one of the things that's interesting about civil liberties and civil rights is that they can be reasonably understood both as part of the framework for American government and understanding American government on the one hand, but they're also public policies. Civil liberties are public policies. Civil rights, or their violation, are public policies. And so, while in most American government textbooks you find chapters on civil liberties and civil rights, at the beginning, adjacent to the material on the Constitution and federalism, as in the case of the Barta's textbook, it's also the case that they are that they are public policy issues. The Congress is established in Article 1 of the Constitution of the United States. That is part of the institutional framework. But so too really are civil liberties and civil rights, but they're also public policy. So it's important to keep that in mind. Okay, so what are civil liberties? These are questions that concern personal freedoms, individual freedoms that governments may not infringe upon, and they include guarantees of due process. Actually, not just individual freedoms, but also freedoms for groups of individuals. So when we talk about civil liberties, we're talking about limitations on what government can do to people. So I want to go through some of the amendments to the Constitution in the Bill of Rights and talk about their implications for civil liberties. And Americans, this also isn't anywhere on the slides. Americans, I think, tend to emphasize, perhaps overemphasize, the idea of rights. And the bill, and the fact that we have the first 10 amendments called the Bill of Rights, tends to help create a political culture in which we believe, the government can't do this, 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 and this to us, or to anyone. And that's not necessarily the case, because the rights, quote unquote, in the Bill of Rights are more complicated than what the common wisdom suggests. So, and my discussion of the First Amendment will I think help illustrate this. So the First Amendment is up at the top of the slide. Can you guys read it?
Yes.
Hello?
Yes.
You can see it, okay. So Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. So this may be kind of boring, but I think it's important. There are two clauses in the First Amendment. One is the establishment the establishment clause. That is just the first line and a half. And the other has to do with the free exercise of certain activities. These include the free practice of religion, speech, the freedom of media to publish and express opinions, and later on, freedom from, with other amendments, the freedom from unlawful search. And generally speaking, what we try to do, what the courts try to do, is to recognize that not only the First Amendment, but also all of the amendments in the Bill of Rights are not absolute, but they need to balance personal freedoms with the rights of all citizens. Furthermore, there are inconsistencies within some of the rights. In fact, even within the First Amendment. We'll talk about that, if not this time, next time. So this is the First Amendment. And from my opinion, perhaps among many others, is the First Amendment is about as great as the invention of sliced bread. It's a good thing. But it's not an uncomplicated thing. So first, let's talk about the origin of the Bill of Rights, okay? And maybe the Bill of Rights is often thought of as sacrosanct, but in fact, we've already discussed in previous classes, the Bill of Rights is a political compromise. It was a political compromise that was made between the Federalists and the Anti-Federalists at the time the Constitution was written. And what the Anti-Federalists demanded as in order to get their support, or at least limit or reduce their opposition to the new Constitution, was a Bill of Rights that would limit federal power, federal government power over persons. And of course, these limitations in the Bill of Rights are subject to judicial interpretation by the federal courts. So civil liberties have changed significantly over time. We've had almost 225 years of the courts determining what the Bill of Rights actually mean. One of the most important things to know about the Bill of Rights is the concept of incorporation. This is a concept that was and a judicial practice that has developed over the years and began most significantly around the time of the Civil War. Incorporation is the process through which the Supreme Court has examined individual provisions of the Bill of Rights and applied them to or against state and local officials and governments. So, what you ask? Well, why do the federal courts have to apply the Bill of Rights and the protections in the Bill of Rights to state and local governments? And the answer, very simply, is because the original Constitution with the Bill of Rights was understood to mean and to be applied only to the federal government. Now, I know this is pretty extraordinary, so let's talk about it a little bit. In other words, what I'm saying is when the Bill of Rights was approved, it was in fact understood by the framers and the early Americans to apply only to the national government because their fear was a tyranny of the national government, that the national government would be too powerful. We didn't have to worry about state and local governments, they thought. Okay? This is interesting since they were burning witches, a century earlier in Massachusetts. But it never occurred to them that the Bill of Rights needed to be applied to state and local governmental violations of civil liberties. And so, once the South seceded and was defeated in the Civil War and incorporated back into the country, Civil War amendments were passed, 13, 14, and 15, and we'll talk about them later on. And those amendments, especially Amendment 14, were used to extend the protections that the Bill of Rights provided to state and local governments. And this has been done very gradually over more than 100 years since the 1860s, 1870s. In fact, it's still going on. And so, again, what incorporation means is it's a process by which the federal courts, as they deal with individual cases that are brought before them, apply, one case at a time, various provisions of the Bill of Rights to state and local officials. Comments or questions about this? So the language that's key in this process, this is a process also known as the nationalization of the Bill of Rights. The key language, constitutional language in this process, comes from Section 1 of the 14th Amendment, which is on the screen before you. All persons born or naturalized in the U.S. and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction equal protection of the laws. So this is language that comes out of the end of the Civil War, where clearly the national government was saying, among other things, to southern states, or those states that seceded, hey, guess what? Slavery's over. These people are free. And you know what? They have the same rights as everybody else. And states aren't allowed, under this amendment, under this language, they're not allowed to oppress people, deny them their equal rights, deny them rights that they have under the law and Constitution of the government of the United States. And this language in the 14th Amendment becomes the constitutional basis for the extension or the application of the Bill of Rights to state and local governments. And note as well that this language only mentions state governments and what they can or can't do, but we also know from previous classes that there is no mention of local government in the Constitution, and that constitutionally local governments are creatures of state governments. So by mentioning states, it automatically means local governments as well. Any comments or questions about this?
No.
Go ahead.
No question.
Okay, so this language is in some ways we talked earlier about the supremacy clause in Article 6, Section 1. In some ways, this makes that language bolder and more powerful than it otherwise would be. Because really what it's saying is, hey, all you states out there, you can't deny American citizens their rights that they have under the Constitution. And if you try to do that, then the question becomes, okay, then what happens? But that's the statement in Section 1 of the 14th Amendment. So, what I want to suggest to you is that in real life, over the course of human history, it is very difficult for governments and human beings and corporations and other large organizations to, in fact, recognize and respect and limit their power with respect to civil liberties. In other words, I think what I'm saying is that there's a fundamental sense in which some of the very basic ideas of American political culture are correct. And this is really a politically conservative idea. People with power, organizations with power, are inclined, whether they intend to or not, to overreach and to use their power excessively, to deny the rights of individuals. I don't think this is simply with respect to, big corporations or the American government. I think it's a fact of social and political and economic life. And one of the reasons we have a constitution is that the framers, I think, kind of held the same view, and that they therefore intended a constitution to define and limit the powers of government. And we've talked about that already. Constitution doesn't really talk about the powers of others in a society, but it does talk about governmental powers and tries to limit them in various ways, and we've discussed some of that. Dictators don't need or want a constitution. They simply do what they want or what they can, or at least they try to. So civil liberties protections are demands that government be restrained when it concerns the freedom, privacy, and autonomy of individual persons. This is asking a lot. If one holds the view that the framers apparently did, that governments and centralized powers tend to use their powers against others in excessive ways, then the idea of civil liberties is really asking government to do things that they're not inclined to do. All right? What a government tries to do, and we talked about this, I think, in an earlier class, what a government in its infancy tries to do is get a territory, defend the territory and its boundaries, raise a military, and levy taxes in order to pay the military and feed the military. In other words, to consolidate power over land and people. So a nation state in its very essence is not about, yes, let's find a way to protect all the civil liberties and personal rights of all these people who live in this territory. That's not what governments are about in their very essence. And one of the things that makes the Bill of Rights special is that some of the framers and many of the early Americans said, hey, hang on here. We need you to police yourself. We need you to limit yourself. We need you to understand that individual persons and groups of persons have some liberty, have some privacy and autonomy, and stay out of it. You can't violate it. Now, the fact of the matter, in real life, is governments, and our government does violate civil liberties every day, probably every hour. Probably every hour in just in a public school. No offense, North Harrison High School, but if I had a dollar bill for every junior high and high school kid who is expelled or detained or whatever for not wearing the right kind of shoes or looking cross-eyed over the course of a year, I'd be a lot richer than I currently am. And that's just one little part of society, public schools. So this Bill of Rights, and in fact, for that matter, any law, they're not self-enforcing. In fact, what we're doing when we try to say we should have civil liberties is we're saying, government, you should limit your powers. You should check yourself. Comments at this point. So one of the most controversial issues that comes out of the First Amendment is religious freedom. The Establishment Clause and the separation of church and state. So again, going to drop this bomb on you, I did it once before. The United States of America never has been and is not now a Christian nation. The great contribution, one of the great contributions of the American political experiment is to say, we're not going to be like Europe in 1770 or 80 or 1790, where the ruler was at the same time the head of the church. We're not going down that road. Nonetheless, we're a religious people, and there are very strong religious traditions, not all the same, in the various colonies and states in early America. So let's take a look at some of the issues that arise out of conflicts regarding religious freedom and the separation of church and state in the First Amendment. There have been many court cases over government aid to church-related schools. And for example, can governments provide, state governments, say local governments, provide vouchers for age 5 to 17 or 18 youth to attend religious schools? And so far the answer appears to be under some circumstances, yes, that's okay. And we'll talk more about that in a little bit. The issue of official school prayer, the key decision here is Engel v. Vitale. It's very common for people to say, God has been taken out of America's classroom. Well, to use a scientific term, that is horsepucky. Anybody, any student can pray anytime he or she wants in a public school as long as it's not disruptive of the academic and other educational activities in the school, number one, and as long as it is not officially sanctioned by personnel of the public school system. Keep in mind, we're talking just about public schools here. That's the critical piece. What Engel v. Vitale says is, if I come into this class and I say, instead of saying good morning class, I say, well, I'm going to determine what the official class prayer is, and everybody has to say it, and then we'll start the rest of class. That is unconstitutional. Why? Because I am a paid employee of state government, and as an employee of state government, I am essentially acting in a manner that says, I am establishing this prayer for you, and not only that, you can't get up and leave. You're a captive audience. And so it's very likely that the prayer I might choose is totally inconsistent with your own religious traditions and beliefs, yet you would be subjected to it. So public school officials cannot be in a position of endorsing any kind of religious activity. The First Amendment also covers controversies regarding prayer outside the classroom. Again, it depends very much on this question of is there some kind of endorsement by a school system or school employees? One of the major controversies in some states is, should so-called intelligent design be taught in science classes? Usually those who argue that intelligent design in science classes should be taught because evolution isn't really real, it's just a theory. The inclination, I think, of the courts is to reject that argument and to say, no, intelligent design really doesn't have anything to do with science. It has to do with religious belief, and teaching religious belief as though it were a fact is a violation of the First Amendment. One of the interesting sets of court cases around the First Amendment concerns religious displays on public property, whether it's schools or city parks or at City Hall or what have you. And the tendency of the courts has been to say that if there's only one religion, and this has gone on in Cincinnati, for example, for some years, if there's only one religion that's represented in a display on public property, keep in mind we're talking only about public property, obviously, as long as there's no violation of zoning ordinances, people can display whatever religious material on their own property that they like. But on public property, the courts tend to say if you have one religion represented in such a display, then others have to join as well, have to be allowed to join. And so there's no endorsement. The argument then is diversity is a way to avoid the appearance and the reality of endorsement of one religion or one religious tradition over another. So, comments at this point, or questions? One of the things that to keep in mind is that policy conflicts and legal conflicts over religion can be pretty intense, which is, by the way, I think one of the reasons that the framers wanted religion out of the Constitution. They knew from the history of their own of Britain that religious strife, and for that matter, history of Europe, that religious strife could be a serious problem for a society. So there is a sense in which there's some separation of church and state, but there's also the free exercise clause that's important here. for individual rights. Individuals can hold, under the First Amendment, any religious belief they like. However, court decisions have said a few practices are restricted. For example, there was a case involving a group in Oregon some years ago, and that group said, well, you know what? We have been, the facts of the case very generally are that there's a state law that says peyote is illegal. And the group said, well, we're a religious organization, and smoking peyote is part of our religious practice and custom. And so we understand that that's the law, but we're going to break that law because we have religious liberty under the Bill of Rights. And that case went to the Supreme Court, and the Supreme Court said, well, it's nice that you have that belief, but smoking peyote is illegal, possessing peyote is illegal, and you're guilty. And the law and the constitutionality of the law is upheld. There are, however, primarily, but not solely in the Internal Revenue Service, there are limitations to what individual religious groups, organizations like churches or synagogues or mosques can do. First of all, these entities are not subject to taxation. And as a consequence of that, they are not permitted to endorse candidates for office or to make campaign contributions, but religious groups are and organizations are allowed, religious organizations like churches, mosques, synagogues are allowed to take positions on ballot proposals and to make contributions on issue proposals that are on government election ballots. One recent example is there was a vote in California regarding whether gay marriage should be legal or not in that state, and various religious organizations and churches gave a substantial amount of money to those who were opposing the gay marriage proposal. Okay, the Lemon Test. The Lemon Test is a critical piece of guiding how the federal courts have come to interpret the Establishment Clause of the First Amendment. And the case is a 1971 case, Lemon versus Kurtzman. And so there's a three-pronged test that the Supreme Court developed in that case to conflicts over church and state. First, does the law or practice have a secular purpose? Now, I'm going to give you some examples once I get done with these three. Second, does the primary intent of the law either advance or inhibit religion, or is it relatively neutral? And thirdly, does the law or practice create an excessive entanglement of government and religion? So let me give you a couple of examples. It's common enough for public school districts, and these are, there are literally thousands of them in our country. Is it constitutionally protected for a public school district to provide funds to religious schools, private religious schools, so that they can bus their students between home and school? And so Supreme Court has applied this three-pronged test to this issue, among many others, and said, yes, this is acceptable. Why is it acceptable? Because the purpose of the monies is not religious in nature, but it is a public safety issue. In other words, Jim and Johnny and Jane have to get from home to school and from school to home safely. every day, week after week, month after month. We don't want kids to get hit by buses. We don't want them to get hit by trucks or cars. We want them to be able to travel safely. Okay, that's a secular purpose, not a religious purpose. Does the law have either advance or inhibit religion? No. What it does, according to the courts, is that it makes it more likely that kids will arrive at school safely and return home safely. Is there an excessive entanglement of government and religion? No, because the law doesn't provide for that. What it does is focus on the safety of the kids who are going to and from school. Now, if you just change one fact, let's say all of the bus drivers are employed by, and usually this is not the case, they're employed by this public school district, but the school district just uses its funds to see that the children are transported. What if the bus driver is actually an employee of the private religious school, and he gets the kids in the bus and every day gives them a religious lesson of whatever that school's religion is? And you guys are in the bus, you got nowhere to go except to be talked to by this bus driver about his own or the school's religious convictions and traditions. That would be overturned. That would be found unconstitutional, more than likely, because the intent then of that practice is to advance one particular religion. It's not just a safety issue. It's an issue that involves, teaching religious belief with using the funds of government to do so. Comments or questions at this point?
Yeah.
Go ahead.
So earlier when you were talking about the contributions to a political campaign, I know obviously you know that Alice Lundergan Grimes is running against Mitch McConnell, and Mitch McConnell has a commercial saying that Alice Lundergan Grimes' dad gave contributions illegally to her campaign. So is there a law saying that a person's family can't give contributions to a political campaign?
Okay. This is an area of that has been very controversial, and Supreme Court cases have in recent years overturned prior practice. There are a variety of state laws that govern the campaign practices and campaign contributions. So each state is almost certainly going to have a different law regarding this issue. That's point number one. Point number two, there's also many states will also have some kind of agency which hears and adjudicates disputes regarding elections and electoral behavior, such as campaign contributions. There's also a similar situation at the federal level. There's a federal elections agency. There are federal laws regarding campaign contributions, some of which have been overturned by the Supreme Court in the Citizens United case. I can think of no case in which any candidate for office has been penalized or where there was any kind of significant action taken against that candidate or that political official for violating a state or federal law, election law regarding campaign contributions. They may have violated them, but these laws at this point are toothless, and they to the degree that they're trumped by two things. First, the ruling of the Supreme Court, and it's been made more than once, that spending money on elections, no matter who does it, the people can spend as much as they want. So if you're a gazillionaire, if you're a gaming magnate, Sheldon Adelson in Nevada, and you want to give $5 million to Newt Gingrich to run for president, and your wife wants to give $5 million, and you want to bankroll virtually his entire campaign, you can do that under the current understanding of the law. And the other thing that has happened with court decisions is that the public financing component, both court decisions and political realities, have made the public finance portions of campaign law very weak and often irrelevant, because the cost of campaigning in many jurisdictions and nationally is huge. So I have not heard Mitch McConnell make that specific claim, but what I would argue, without respect to Mitch McConnell, but in general, is that the campaign financing system in our country is so broken that there are problems with every candidate, almost certainly. And what that really is, that kind of claim, political claim in a campaign, is really an effort to shift people's attention from substantive and important and compelling issues to those that are less important. I mean, this is like the pot calling the kettle black, in other words. I don't like saying that everybody does it, except that's what the Supreme Court has essentially done, by basically saying anybody can pretty much give any amount of money they want. And yes, there are rules here and there, but you cannot name me one candidate at any state or federal level who has suffered because of campaign finance improprieties or illegalities. I don't think they're out there. I'm not saying it doesn't happen at the local level. You know what happens in Colorado cities, I don't know, but we're in a situation now where candidates can basically raise money from anywhere. In fact, anywhere. Now they can raise money from abroad. American corporations have huge sums, gazillions of dollars held in financial institutions abroad. If they want to bring that back or find a way to contribute to a political candidate, they can do it. I mean, if her father gave money to her to run for office, that's, I don't know if you've ever heard this term. I would say it's pish posh and chicken feed. It doesn't matter. I'm not saying it's right. I'm not saying there may not have been. I don't know the facts of this particular claim, but this is a really serious problem with the American electoral system. So I can't comment specifically on the Grimes-McConnell issue that you've raised because I don't know enough of the specifics. But even if it were totally true, does it matter? I guess that's the question. Is it significant? I would say par for the course. And I hate saying that, but I'm afraid that's where we are. Other comments or questions? I know we're out of time. Any other comments or questions? One other point on your question. The courts have ruled that making campaign contributions, that money is in fact political speech. And I might add, the irony in your question is that Mitch McConnell has been one of the foremost proponents of the claim that anybody ought to be able to give any amount of money they want to any candidate because money is political speech. And for him then to turn around and accuse somebody else of the very thing that he's been advocating for decades is pretty darn hypocritical. Any other comments? Next time we will pick up with a recent case still dealing with religious issues, the Hobby Lobby case, recently decided by the Supreme Court. See you guys next time. Remember, if you have questions about the assignment that's due on Sunday, please do not wait another day to ask. What?
No, I put it off the
Yeah.